Hello everyone and welcome. My name is Nick Richards and I'm the General Counsel of Cambridge Innovation Capital, or CIC. CIC is a deep tech and life science venture capital firm that invests in growth businesses. It gives me great pleasure to welcome you all to this webinar on the UK's National Security and Investment Act, recently enacted to give the British government wide-ranging powers to investigate corporate transactions within specified sectors on grounds of national security. Those sectors, which include several verticals within tech and life sciences, are a significant focus of CIC's business, those of our investee companies and our contacts in the ecosystem. In the US, the Committee on Foreign Investment in the United States, or CFIUS, has for some time had the authority to review foreign investments in US businesses. There are several parallels with the new UK regime and learnings that can be taken from practice as it has evolved in the US. I'm therefore delighted to be joined by experts in this area, Ross McNaughton and Sarah Cole from Taylor Wessing in the UK, and Stacey Kim and Joshua Greenspecht from Wilson Sonsini in the US. This webinar can run for up to an hour, and I'll shortly hand it over to the panel to introduce themselves and the UK and US regimes. After that, we'd be very happy to respond to questions from attendees. So please do submit questions through the Q&A window at any time, and we'll look to address those during the time we have. One point on housekeeping, we'll be recording the webinar and the content will be shared through the CIC website in due course. We'll also circulate the slide deck to attendees following the session. So with that, I'd like to hand the virtual floor to Ross.
Thanks, Nick. And yeah, hi everyone. Thanks for dialing in. So by way of introduction, my name is Ross McNaughton. I am a partner at Taylor Wessing in the corporate technology and life sciences teams. For those of you who don't know us, Taylor Wessing is one of the leading tech and life sciences law firms. We help companies all the way from inception through to exits. We've been following the National Security and Investments Bill as it was and now Act very, very closely. I think it's going to be quite transformational when it comes into force properly. We have also put in several submissions and lobbied for a few changes, both directly and indirectly, when the bill was going through Parliament. And we can touch on those a little bit more when we get on to it in terms of the substance. But just handing over to my colleague, Sarah.
Hi there. Yes, my name is Sarah Cole. I'm a senior associate in the Taylor Wessing corporate technology team. I'm currently in London, but I'm usually based in our San Francisco office, and we have a small rep office on the West Coast to help with our North American clients and helping them to go international and with their international needs. I'm handing over to Wilson Sonsini team.
Hello, my name is Stacey Kim. I'm a corporate partner in the London office of Wilson Sonsini. Wilson Sonsini, we were the very first tech and life science focused law firm in the US. And as part of the mandate for Wilson Sonsini in London, we represent European companies accessing the US market and also investors who want to invest in US companies. Handing it over to my colleague, Josh.
And hi, bringing up the rear, I am Joshua Greenspecht. I'm a partner in the National Security Group of Wilson Sonsini, based in Washington, D.C., one of our East Coast offices. Here, I focus on national security matters of various types for our broad array of tech and life sciences focused portfolio companies. In particular, for purposes of this webinar, do a tremendous amount of work before the Committee on Foreign Investment in the United States, or CFIUS, which is the US equivalent FDI regime to the bill that the UK is putting in place right now. CFIUS's authorities were substantially reformed back in 2018, and that has had a significant impact on the way that we look at investment in the United States into tech and life sciences companies. And so here to talk a little bit about that past experience and how it might inform the UK NSI bill experience that the UK is about to go through in the next or coming months and years.
Great. Well, thanks, Josh. Thanks, everyone. And so, I mean, just to kind of set the scene, and in fact, just taking a bit of a step back, what we're going to do in terms of format. So we'll go through, we've got a couple of slides both on the UK and the US regimes just to set the scene. As Josh kind of touched upon, one of the things that we're quite keen to do is to really understand some of the learnings that we can take from the CFIUS regime in terms of what's coming down the pipe here in the UK, and how we might be able to prepare ourselves a little bit better for this new regime that's coming into force. And again, just to kind of use that word transformational again, I do think that this is going to have a pretty profound impact on deals going forward. Just to kind of set the scene, the Enterprise Act 2002 is where the current regime is for national security investigations to the extent that the government wants to make them, right? So currently it's kind of embedded within the competition regime for the UK. So the Enterprise Act generally provides that the Competition and Markets Authority can has power to intervene in relation to certain transactions. And there is a threshold of those transactions, which is that they have to have, the target has to have a turnover of 70 million sterling, or it needs to have a 25% share of supply. There is a part of that regime which allows the CMA to intervene on public interest grounds, including national security, media plurality, and financial stability. And to date, there hasn't been any intervention under the national security auspices themselves. That was also there was also a fourth limb added in when the coronavirus hit last year to allow intervention in relation to public health emergencies as well. And for that regime has stood for the best part of 20 years, and to be fair, has not seen a massive amount of intervention from the government over that time. So I think there's been around 12 interventions in that 20-year period or 19-year period. And so a few years ago, under Theresa May's government, the government decided to look at that a little bit more closely. And so first we had a green paper and then a white paper, which looked to implement some short-term fixes and then some medium-term fixes to give the government just a little bit more power to take a look at some of these transactions to the extent it wanted to. So the short-term fixes were to introduce some specific areas which did not require the full 70 million revenue threshold. So that turnover threshold was brought right down to 1 million for military and dual use companies, for computer hardware and technology, and for quantum technologies, and also for enterprises concerned with AI, cryptographic authentication, and advanced materials. But the medium term fix was to introduce the National Security and Investment Act. And with that, I'll hand over to Sarah, who's going to walk us through what has been proposed.
Thanks, Ross. Yeah, so just to sort of give you an overview of the key elements of the Act, and particularly why we think this requires quite immediate attention from companies in the technology and life sciences sector. And primarily that's because if you're considering a sale or an acquisition or investment into your company, this Act could already have an impact. Part of it has retrospective effect, and it also has extraterritorial effect. So it's very wide. We'll go into detail as part of the webinar more generally, but just as a headline, the Act introduces a mandatory regime. It's got two regimes, a mandatory and a voluntary. And the mandatory regime requires notification and clearance through a process for certain transactions when relevant thresholds are met. And if the business operates in one or more of 17 sensitive sectors, or what the government considers to be sensitive sectors. I'll put them up on the next slide, but they're very much tech and life science focused. including things like advanced materials, synthetic biology, artificial intelligence, computing hardware, things like that, cryptographic authentication. And if you fall within, if the business falls within one of those 17 sectors and the thresholds are met, then the notification process is mandatory. And you do need to make that application and get clearance before proceeding. So it's that and the part of that that part of the regime is going to be coming into force a bit later this year. Whilst the Act has received royal assent in the end of April, the mandatory element of it is not yet in force. We're expecting that by the end of the year. And then the second part of the regime is a voluntary element, and this is a little bit more nebulous. It arises if certain triggers are met, and particularly the area and sort of the relevant part is whether or not you think the transaction is likely to trigger any kind of national security risk. If you do think so, and we'll come on to the triggers, but you think that those will be met, then you can voluntarily notify your transaction. It is a bit more nebulous of the two regimes, or two parts of the regime, given that what constitutes a national security risk isn't specifically defined. And secondly, the government has a 5-year look back on transactions, which and the part of that look back is already live. So to the extent that a transaction is likely to trigger or has a trigger and a national security interest implication, the government can look back to transactions that closed from the 11th of November 2020. So the key element there is to note that if you think that you do have you have just recently gone through a transaction where there's some change of control that may have a national security interest, it's worth getting advice on any implications. A few just general points to note that they're on the slide there. As I mentioned, there's a clearance process where there's an online portal for notification to BASE, which is the government department managing this process, and they've hired a big team to make sure that it's as smooth as possible. The BASE has 30 days from what they say is a sufficient or satisfactory application in order to provide clearance. They can extend that on certain cases. Also interesting to note that the Act captures assets as well as sort of a share purchase. So if there was a sale, if you were buying, acquiring, or selling an asset, that could be triggered. That could trigger a notification requirement. It's not clearly defined yet. That's going to come in secondary legislation, what that means. And there's also an extraterritorial impact, so it's very broadly drafted and means that, for example, if there was a US company buying a US company, but there was some UK nexus, then it could be caught. Sanctions are quite heavy, so worth bearing in mind. I think it's 5% of global turnover, or £10 million, whichever is the greatest. And there's also a criminal element to those sanctions as well, so potential 5 years imprisonment in I suspect very extreme cases. And the other very relevant implication is that the transaction could be void. I'm just moving on to the sectors that are caught within the mandatory notification. There's a slide on. So yeah, on the slide there's the 17 key sectors. As I mentioned, many of these are very focused on technology and life sciences. Whilst the consultation as to the definitions of those sectors and what would be triggered closed on the 6th of January, the government is still taking feedback on that. So if you're interested to review and see whether or not you wanted to make any comments, that is still available to you. And then the other slide here, which hopefully is helpful, just provides a little bit more information about what these trigger points are. So if you have I think I've covered the first three sort of rows here, but on the fourth row down just talks about who is responsible for making the notification. In the case of the mandatory regime, that's the person acquiring the investment or acquiring the company. For the voluntary regime, that's any party. And then in terms of the triggers there, so in the left-hand column, the mandatory notification, So if the investor, or if you're selling a company, or if there's a change in ownership from either between 25% to more than 25%, under 50 to over 50, or less than 75 to over 75, then that triggers the mandatory notification if you're within one of those 17 sectors. And the win, I suppose, that business has had is increasing that threshold, that minimum threshold, from 15 to 25%. A little bit more nebulous on the voluntary notification, where if there's a material influence, that's the sort of trigger where the acquisition would enable the person to materially influence the policy of the company or the entity. So a little bit harder to define. So, very happy to take questions and discuss this all in a little bit more detail in due course. But that was sort of all we had, just as a general overview of the regime. And with that, I'll pass over to Stacey to talk a little bit about the CFIUS regime.
Great. Actually, I'll just take very brief.
Oh, sorry, Josh.
No worries. So I think, one thing that's helpful to think about in the context of the UK implementing the new regime is what parallel countries have gone through in implementing similar changes. And so in that context, I think, helpful always to think about CFIUS, which has been around for a long time, but which underwent some substantial reforms back in 2018. And I think in some ways, those reforms have engendered a wave of reform in countries across the globe. We've seen, major reforms in Australia, in Germany, in France, in China, in Japan, all after the sort of 2018 CFIUS changes. And so I think we're just going to briefly talk here about sort of the way CFIUS works, and then use that to inform the conversation that we're going to have on the UK NSI bill. So when we think about risk, when we're talking about companies that are potentially US businesses for CFIUS purposes, we think about it in the context of, largely raising capital. The CFIUS regime applies to investments, and an investment for CFIUS purposes, may mean seeking equity investment, may mean engaging in an M&A transaction, planning to exit to an acquirer. In some cases, it can even include transactions like joint ventures, where the joint venture involves the taking of a particular piece of the business and moving it over into the joint venture. That can be considered an investment into that existing business. Even in rare cases, CFIUS can take a look at things like licensing agreements if it thinks that they are designed in a way to sort of circumvent the regulations with respect to investments. And so, some key points regarding the rules. This parallels some of what Sarah's saying, look to be, the ways that the UK NSI bill looks to be implemented in the near future. There's a small subset of transactions that must, as a matter of law, be filed with CFIUS. I think a smaller subset than the initial look at the NSI bill would suggest in the UK. There's a much larger set of transactions that are within CFIUS's elective jurisdiction, where CFIUS is allowed to step in, and it's up to them to determine whether or not there's enough national security interest for them to do so. As part of the 2018 reforms, CFIUS stood up through 2019 and into 2020 an enforcement team. That enforcement team is now very active. It's going out and looking at transactions, largely those within the elective jurisdiction of CFIUS. And so for that reason, I think it's not safe to just think about the narrow set of transactions for which filings are required. You have to think about the broader jurisdiction, because the enforcement team is out there looking for unfiled transactions. Now, because it's a national security regime, it does largely look at investments that it views as national security risks. And so in the context of the United States, that means we've seen a lot of enforcement actions with respect to Chinese and Russian parties. And also parties that aren't Chinese or Russians, but have connections to those regimes, or have connections to Iran or other bad actors, or who themselves have been violators of US law in the past. Those are the kinds of parties that we see more enforcement action with respect to. CFIUS also recognizes a category of sensitive businesses. This is part of the definition of what is a required filing. businesses that are what we call TID businesses in certain sensitive technology, infrastructure, or data areas. That's a little bit different than the 17 sectors that we talk about that Tara talked about in the UK NSI bill. It's defined more by what a business does than by what sectors it's in. But that sort of does serve as a roughly parallel idea for these are the sectors where there may be a mandatory filing if you're a TID business. When we think about how we deal with that in an investment context, and I talk to Stacy and her team all the time because we always are thinking about how to deal with this in an investment context. Many parties look for reasons not to file, right? Because the filing is costly both for in time purposes and because it carries legal costs. Structuring techniques are often used to minimize foreign influence or allocate risk. In particular, parties often rep that they are not subject to CFIUS because, for example, they're not a foreign investor at all. So if you have a UK investment, you may immediately start seeing people who are repping, I'm a UK investor, so I can invest in a UK company without triggering the NSI bill. In the CFIUS context, it's important to note CFIUS doesn't have a statute of limitations. So that allocation of risk is an allocation of ongoing risk. It's always possible CFIUS can knock on your door. They never run out of the ability to do so. So I think that those are some key high points to hit on the CFIUS front. I don't want to spend too much time talking about CFIUS. We do have a number of slides here sort of giving some background on the high level and how the regime works. But I think we're largely here to talk about the lessons learned in the CFIUS context for the NSI bill. So I think we should probably move on from the slides and start in on the Q&A. And so for that reason, I would hand it back to Ross to kick us off there.
Great. Thanks, Josh. So, so obviously, I mean, you've seen from the slides that we've obviously got a bit of a paradigm shift coming in terms of this aspect of the government really looking to take more of a proactive stance in looking to intervene in transactions. And again, just to kind of give some context and some numbers. Against the kind of 12 or so enforcement actions over the last, or interventions over the last, 20 odd years, the government in its or in its papers that accompanied the bill was expecting, something in around the region of somewhere in around the region of 1,000 to 1,830 notifications a year, which incidentally we still think is probably quite light. We think that there'll probably be a few more, more than those. And then of those, they would expect to look at around sort of 75 to 90 a year, and then potentially to intervene in around 10. And so that's a kind of quite a big sort of paradigm shift again for us. And so one thing that I'm really keen to sort of understand and to hear from you, Josh and Stacey, is in relation to how that kind of played out back in, I think, was it 2018 when FIRMA sort of, introduced the sort of, mandatory filings, the TIDs concepts, etc. What was it like at that time? And are there any sort of parallels from what you saw there, both in terms of people gearing up and preparing for the for the regime coming into or changing, and then how they sort of saw it settle and market practice then eventually sort of evolved from that? What just talk us through that a little bit, if you could.
So do you want me to start off with this, Josh?
Yeah.
Okay, so CFIUS, it's been around for a long time. It's just with respect to the changes in 2018, it became relevant in the world of technology and life science companies at the early stage and the growth stage, life cycle. So, as a practical matter, when we represent, life science or technology companies, and I'm going to talk about it from a US perspective before we talk about, a UK perspective. But when we represent US technology and life science companies that are, seeking to receive investment from non-US investors, early on, it becomes a risk analysis, at least in the beginning, to determine, whether or not there may be an issue. And so we quickly have to, look at the number of investors involved and where they're from. We also have triage questions that we go out with to determine who's behind those funds, because you could have, say, a UK fund seemingly very innocuous, but at least in the eyes of CFIUS, they look through that and they will look at the LPs. So we work closely, the deal teams, at Wilson Sonsini will work closely with the CFIUS team that Josh, heads, and we'll do some triage questions, and then we'll determine if there's certain investors involved, and if the deal terms are asking for certain rights and levels of control, like board seats, information rights, certain certain transparency rights, triggering rights for control. Then we will work closely with the CFIUS team to determine, okay, do we fall into the area of mandatory filing regime, or is it recommended that we do a voluntary filing? And as Josh mentioned, especially at the early and growth stage level, all actors, including the investors actually, that might be implicated, are very sort of cooperative in trying to create a deal structure where they won't be, it won't be scrutinized, because in that case no one wins, because everyone wants to do the deal at the point that we have the term sheet signed and we start doing this CFIUS analysis. And from the investor side, as a practical matter, the non-US investors that we represent, who actively invest in US companies, or what we call US businesses. So for example, it may be a UK company, but because of their footprint in the US or their nexus to the US, they would be considered as a US business and captured potentially under the long arm of the CFIUS regime. We actually, will recommend that those funds, those investors, sort of undertake an analysis of whether or not, their investor makeup would make them fall under the mandatory filing regime, as on a general basis. So Josh, I think given that you used to work at CFIUS, and you saw this play out, at least, the expansion of the CFIUS sort of regulatory arm, what was your experience in terms of how your team developed and how your team has been utilized in terms of, being, inserted into deals, especially at the early stage and the growth stage?
Yeah, for sure. And I should take a step back and note that I was part of the intelligence apparatus of the U.S. government, but not specifically part of CFIUS.
Sorry about that.
But yeah, I mean, I think that it was a big paradigm shift through sort of 2018, 2019. We did see a number of companies that said, sort of think of themselves as being, in some sense, being regulated at all. Or if they thought that there was any regulation that applied to them, they were thinking in terms of maybe the U.S. Food and Drug Administration, or sort of the things that apply to classic life sciences regulation. It wouldn't have occurred to them to think of themselves as national security regulated. And as the regime rolled out, there was, I think, sort of a real couple of months of absolute panic. I would describe it as, where people didn't know what it meant. And there were a few months where every deal had to sort of come to us and, talk to us personally and make sure that everything was okay. As the months and sort of years have rolled by, we have, as Stacey said, sort of put in place standard practices that we use to try to triage. Deal teams have gotten smarter about what they do. We've developed in the United States a set of standard contractual clauses that are used all the time in the context of CFIUS deals to basically allocate risk to one side or the other by saying, I, the investor, promise you I'm a US-based investor, so you don't need to worry about CFIUS. Or I, the business getting investment, promise you, the investor, that I'm not what CFIUS calls, again, a TID business, this sort of category where mandatory filings may apply. So, if CFIUS has an interest, it would only be if you guys were taking a controlling stake. And through the use of that kind of standard analysis practices, standard language, we've streamlined a lot of the kinds of analysis that we used to do. With that said, I mean, it is still the case at a fundamental level that we need to talk to a lot of different clients about this. And, I can say that our group, for example, in the last 12 months has worked on more than 1,000 investments, and that's that's a lot, right? And, I mean, at some point, most investments talk to us, and most investments talk to us only for an hour or two, right? And then we can sort of say, there's a way to resolve this so that it's not an issue. But it does, provide this sort of little extra regulatory barrier that people need to talk about. And for the people who get caught up in the process, for the people for whom CFIUS can potentially be an issue, it is potentially sort of long and uncertain in that regard. And so, it is something that for most people can be dismissed quickly, and for a few people, does provide some more significant regulatory barriers. Ross, I think you're
on me. So how long did it take before you started to get a bit of a sense from CFIUS as to how they were going to enforce the new regime with the mandatory filing piece in particular? Well, one of the things that we're looking forward to be honest, is there's alongside the National Security and Investments Act is going to be a statement of policy intent from the Secretary of State from BASE. So a draft of that was published back in November last year when the bill was laid before Parliament, and the government has said that they will consult on that. So we're hoping that will give quite a good steer as to how they're going to implement this in practice, because necessarily, I think, so sort of many parts of the regime are quite open-ended. So concepts like national security is not defined. There was a lot of attempt within Parliament to try and get it defined, but they didn't want to do that. And also, it catches a lot of different transactions. So, it catches any transactions, regardless of whether or not you're a UK investor or a non-UK investor, for example. So we'll see that. But how long did you see did it take for you in the US for the kind of enforcement sort of protocol to become a bit more apparent from CFIUS's actions after these changes?
Yeah, no, it's a great question. I think we had some advantages in the CFIUS context. The CFIUS regulations, have been around for a long time. The most recent renovation before 2018 was in 2008. And so, we had a bunch of terms that were defined, so we didn't have to think about, sort of what was a national security interest and so on and so forth. And that was an advantage. It was also a disadvantage, right? Because a lot of those definitions had been built out with the assumption that the kinds of transactions CFIUS was going to look at were huge M&A deals, right? Where a foreign company was buying a $10 billion US company that did a ton of different things. And, a lot of the sort of the conception of what the CFIUS regulations needed to cover was very focused on M&A, even though it's true that the 2008 regulations technically in a lot of ways covered a lot of venture investment also. That just CFIUS didn't have the manpower to go look at it. And so there was really, it sort of rolled out in the US in stages. We actually specifically contemplated under the statute was a pilot program, basically a temporary program that was put in place to put in some of the authorities that CFIUS had into effect, but not all of them. And soon after the bill passed, they put exactly that kind of program, that pilot program in place, and that existed for about 15 months. And so we got the opportunity to see some of those mandatory filing rules in place at that time. It was sort of a little bit of a proving ground for the idea of having mandatory filings. And, in that context, CFIUS did iterate a bit. We got the regulations hard on the heels of the passage of the bill, and no one fully understood what they meant at the time. And there was a lot of, I think, overfiling of transactions based on what their intent was. They issued a series of FAQs to the public about a month or two in after the pilot program was issued that helped, I think, calm things down a little bit. And so it was very iterative in that way, and I would not be surprised if that was the experience that you have on the NSI bill as well.
Yeah, no, I think that's probably right. And so we've had a question in from the chat function, which and maybe Sarah, you might want to have a go at this one. But it says CFIUS is both a very time-consuming and expensive process with significant uncertainty over outcomes. What is the UK process likely to be in comparison, and can we be confident the compliance department will be adequately resourced. And I could jump in as well if you.
Yeah. I think that BASE are they've put in place a new team, and they've hired a lot of people and are doing done a lot of training to start this process. We've actually within Taylor Wessing been making some initial applications for guidance where that we have thought that there may be a voluntary notification requirement, and so that sort of look back that I mentioned earlier was triggered. And in those processes, BASE have been very good. We've made our applications and had meetings with them where they've really been trying to give as much guidance as possible around the process. In terms of timing, there's at the moment the idea is that will be a 30-day clearance process. So assuming it's a relatively straightforward application, you fall within one of the sectors, you're making your mandatory notification, and from the presentation of that application and it being satisfactory to the BASE team, they've got 30 business days to come back, so it's 5 or 6 weeks. Now obviously that's quite a long time, and it remains to be seen, I think, whether that can be expedited at all. I think that one of the issues and one of the concerns that we have a little bit is that BASE mentioned that they're expecting around 1,000 to 1,800 applications per year. I think our experience suggests that might be quite significantly higher, so that there may become a bit of a backlog. But I think that there's been quite a long consultation process. Lots of parties have provided submissions in that regard, and this is an area of particular concern to industry. So certainly they're trying to address that by being as prepared as possible. I don't know, Ross, whether you had anything else that you wanted to add to that.
Yeah, no, I mean, I totally agree with all of that. Yeah, so BASE have been pretty responsive, and have they have been listening to some of the the concerns that industry has had, and one of the numbers bandied around in terms of the mandatory notification regime when it was going through Parliament was someone had estimated that there would be 10,000 mandatory notifications a year, and I think, to be fair, off the back of that probably led to the removal of the 15% mandatory threshold, which was one of the things that was giving us the most heartburn in the venture capital context. Many venture capital deals, as you probably know, involve an acquisition of or an investment of more than 15% of the shares in a company, and that would have required a mandatory notification to the extent that the company in question, the investee company, came within one of the 17 key sectors. And of course, as Sarah said, there's 30 working days from BASE accepting your application for them to respond. But of course, there is the possibility that they don't accept it in the first place as they're looking for time, or that they come back and ask you further information. And so we were a bit concerned about that, and also the 15% didn't really make sense in terms of a requirement to put in a notification, because it didn't in itself give any rights. It didn't give any rights on the government to actually call in that particular transaction. If you remember back to Sarah's slide with the matrix, the only or the times in which they can in which they can put in a transaction is if there is material influence, and that is not necessarily linked to 15%. It could be, it could actually be less. That 16% there is based on competition case law, but they're made clear in Hansard throughout the consultation process, the debating process within the Lords, that material influence can bite even if you take less than 15%. So in answer to the question, it's kind of wait and see, I'm afraid. I think there will be a bit of bedding down to do, but that they're clearly gearing up, and there's talk about this unit being 100 person strong. So is clearly a sizable unit within Base. And on that point on material influence, I did just want to pick up on that on our next question, actually, and this is a question to Josh and Stacey. So one of the things that we're keeping a very close eye on is this concept of material influence, which comes from competition law, and typically a lot of the case law around that, most of the case law around that, is benched on large stakes in large listed companies. Whereas, of course, here we operate a lot in the startup community. The UK's got a great growth scene going on, and the knowledge economies are clearly one of the cornerstones of the UK economy, or going to be going forward. And so when you've got a VC investment, as you know, Josh and Stacey, there's kind of a whole host of negative control rights. There's a whole host of influence that the investor can potentially make through either a board director or an observer, the ability to input and or approve a business plan, a veto on different types of funding, all of that sort of stuff. So and that, of course, if the investment is also considered to give rise to national security issues, which, again, as mentioned before, we don't know what they are, because they're deliberately kept outside of undefined, that could lead to call-in powers for the government. So do you have kind of how does that work in CFIUS, and what do you do when when you've got a potential investor from overseas, in your case, that's looking to take an investment and looking for standard kind of VC rights, but that could give rise to material influence or control?
So, Stacey, do you want me to start on this one?
Yeah,
and then,
yeah. And I'll follow up just from sort of a deal perspective.
Sure. So, I mean, it's a great question. Obviously, it's a huge preoccupation of most of what we do when we think about CFIUS in a deal context. So, for the CFIUS regime's purposes, there are 4 rights that we sort of consider triggering rights. 3 pertain only if the target is a TID business. The 4th applies to every U.S. business, and that 4th right is what we call control, and it is intentionally in the regulations left very nebulous, left open to CFIUS interpretation. And so we are sort of perpetually discussing with people what the boundaries of control are, how many rights a VC would need to take before it really has control for those purposes, and then whether any of the other 3 triggering rights are triggered if we have a TID business at issue. Control for our purposes is largely defined more by what it is not than by what it is. Control under the CFIUS regulations is not a passive investment of 10% or less made for purely passive investment purposes. So if you, the investor, are okay taking an investment of 9.9%, not getting a board seat, not getting any of those protective provisions that allows you to prevent the portfolio company from issuing debt, or prevent the portfolio company from issuing shares below a certain price, or prevent the portfolio company from dealing in cryptocurrencies, all the kinds of protective provisions that we sometimes see VCs want. If you're comfortable without any of those, then you can make a non-controlling investment, and that's great. To the extent that you want a board seat, and control can be granted even with 1 board seat if the board has unanimity provisions with respect to certain decision making, or if you need those protective provisions that allow you to block certain decisions, then inevitably you're in a situation where you're kind of in the nebulous realm, where what you've done therefore might be deemed by CFIUS to be control. In addition, when you're dealing with a TID business, there are very hard lines where a board seat is automatically a trigger for jurisdiction. Involvement in substantive decision making of the company. So just getting a standard management rights letter can be automatically a trigger for CFIUS jurisdiction. And so, negotiating these rights back and forth, determining whether the VC may be able to do without them, especially if it's not leading around, is the subject of a lot of discussion. And if it determines that it really needs the influence, right, and many investors do, right? Many investors say, if I'm going to invest in a company, I want to be involved in the company. And passivity is not really an option for me. then in that case, then we sort of start, usually then we flip and we start working from the company angle to see like how risky is this company, especially in the context of the investor, very different from a national security substantive risk perspective. If the investor is Canadian or Australian or UK entity versus a Russian or Chinese or Iranian entity. And so, we after we determine that the rights can't be removed, then we sort of flip to thinking about the questions of the actual material risk and where the company falls.
Right. And, from a deal perspective, that's just sort of how, we approach it also, in that, we do take a look at, who is the investor, because for the majority of the deals, all the investors, they do want to have these control rights, especially if they're leading. They're going to want to have a board seat or board observer seat. They're going to want to have negative controls in place. So I would say for 99% of my deals, that's just going to be a given. So then we immediately look at, okay, what is the actual risk analysis or the actual risk that this is going to be an issue? And then we have to look past through the investment entity and look at the LPs. And, for those jurisdictions that Josh mentioned, and to be clear, the CFIUS regulations, in the US, they don't pinpoint these particular countries. But, from what we've seen, how the regulations have played out, those are the jurisdictions that, we will have a heightened sort of awareness and take a closer look.
Yeah, perfect. And Nick, just bringing you in to this question as well. I mean, just generally, I know this has been on CIC's radar ever since the bill was laid in front of Parliament back in November. But I mean, what kind of things have you been doing to date? And from a BC perspective, how do you see things might play out going forward too for you?
Well, I mean, as you say, we've been following the legislation since its announcement in Q4 2020 and taking advice that you and your team, Russ, got on the line and briefed our investment team back end of last year. The only practical measure we've taken to date is, and this applies on the basis of the retroactive nature of the bill as it was first laid before Parliament, that has been that we've incorporated into our investment process a line item in our deal checklist that forces us to consider whether the NSNI legislation is or may be potentially relevant to a transaction. So that's considered as part of our deal process now before we consummate any transaction, and we've been doing that since November last year, in fact.
Yeah, great, thanks. And so I just wanted to just pick up on this concept of national security. So I sort of mentioned a little bit earlier, Josh, that it's so I mean, again, just looking at the regime as it's going to bite in the UK, it's not relevant for the mandatory notification piece. So whether or not you are, there's a national security concern. If you're in the 17 specified sectors, you make a notification if you're tripping up one of those thresholds. But there's this more sort of like subjective analysis that we need to take and try and forward guess in terms of how the investment security unit within BASE is going to view some of these other transactions which fall into the mandatory notification regime, which will also cover assets, licensing, that's the material influence piece, all that sort of stuff. But again, national security is not defined, and there was some push to the government to try and get them to define it, and there was a fair bit of debate within Parliament as to whether or not that should happen. But there was a pretty strong stance that actually no, as soon as you start to get into that, it's quite difficult. So how does CFIUS treat that? Do they have the same concept, or do they try and go into what national security is a little bit more in the legislation and all of the guidance?
Yeah, so I mean, it is certainly the case that I think the same general principle applies, that the mandatory regime is defined by certain thresholds in our case, not the 17 sectors, but the sort of this idea of a TID business and certain other aspects of the investment being met, if you are a TID business, can lead to a mandatory filing. And that has nothing to do with what nation you're specifically from. It has everything to do with sort of meeting those specific thresholds in, and some of those thresholds have to do with, in some sense, a broad definition of national security, right? Just as I assume the UK government picked the 17 sectors it did based on an understanding of what matters to national security. Similarly, Congress put together a definition of TID business that's actually in the statute that was based on its sort of understanding of what was relevant to national security from a business side. But the investor side considerations really don't come into it at the mandatory filing stage, right? That is part of the more subjective aspect of national security that you're talking about that really comes into play when we think about risk on a holistic basis and, the possibility of CFIUS taking a hard line with respect to definitions of mandatory filing, CFIUS bringing you in under the elective jurisdiction. Again, the regulations don't speak to specific countries, as Stacey said, but there is this sort of generalized mission that CFIUS has to look at national security. And in terms of the definitions there's a lengthy iteration of things that CFIUS is permitted to take into account when thinking about national security. It is laid out in the Defense Production Act as amended by FIRMA, the law that passed in 2018. It was a long list before FIRMA. It's an even longer list now of things that they're allowed to think about when they think about national security. And basically, what I would say in terms of the definition is it has turned into, in the words of sort of a famous Supreme Court case here in the United States, something that when you see it, because that fundamentally is kind of what it is. It's what CFIUS wants national security to be that determines what is relevant to national security, more so than any specific iteration of listed possible considerations that matter to national security that you can find in the statute or a regulation. It's experience. It's just reps of running through the regime that allow us to know sort of what CFIUS cares about.
Yeah, no. And you hit on an interesting point a little bit earlier in relation to the definition, the TID definitions themselves. You're right. Like the UK government didn't just pick those 17 sectors out of the air. But the thing is, when you've got those 17 sectors sitting there having a mandatory notification requirement, if you fall within the voluntary notification regime for a reason other than the sectors. So again, for example, if you take control over an asset, or if you take a material influence, but you take a 24.99% stake rather than 25% stake, I sort of do wonder whether there's a presumption that you should therefore be that you're within the kind of realms of the national security regime. So that aspect is ticked. So then it becomes a kind of risk analysis as to whether or not you make that notification in the first instance. So that sounds similar. And then the other thing that's quite interesting about the UK is they did have said in the commentary is that this is not a move back towards the national interest regime. So before the national security regime, and as is currently in place through the Enterprise Act, there was a regime that could prevent stuff in relation to protecting jobs and that sort of stuff. That this is squarely intended to be just in relation to national security, not more of a kind of national interest type test. And I'm conscious of time, but there is just one more point that I just want to examine as well, and just to pull out a little bit in terms of how it works here in the UK, or will work in the UK, and that's in relation to particular size of transaction. Josh, you mentioned it a little bit earlier, but so again, the regime here is not going to have a de minimis level, right? So any investment whatsoever is going to potentially be caught, even if it's under $1 million. The target's got under $1 million of revenue. And so, I'm quite interested to see how that's going to play out in practice as well. What do you, again, if you could just kind of maybe reiterate how you saw things play out, particularly after FIRMA? Are they just interested in the big transactions, or do they go after some of the smaller investment rounds as well?
Yeah, I mean, I think that is, so, you know, the definition of control, even back before FIRMA, you know, was a very broad definition. And in some sense, the reason that it, as I said before, sort of CFIUS pursued large M&A deals was because that's what it had the resources to do, right? That's what it had the resources to find. You know, it could read the front page of the Wall Street Journal and know what things it might be interested in, as long as it was comfortable. Then those were the only deals that it really needed to pay attention to. Now that's not true anymore, right? They've got a lot more resources and they are looking deeper. And there's never been a monetary threshold, a sort of de minimis threshold, as you suggest, to CFIUS. And increasingly that's becoming relevant as they chase earlier and earlier stage deals. You know, when I think about the enforcement matters that we've worked on over the last, 12 months, 18 months since the enforcement regime was really in place, the enforcement group was really active. We've seen enforcement cases related to seed stage investments, to Series A rounds, to Series B rounds, to M&A deals, basically every stage. It is the case that CFIUS is out there looking at investments that companies take of various sizes and kinds all the time. I have a client right now who's very frustrated by the fact that they're, sort of an investor in an accelerator, and they are investing, $50,000 in a company. And unfortunately, I can't tell them that CFIUS won't look at that or can't look at that, because unfortunately that is the case, that CFIUS does look at tiny investments if it wishes to. In fact, it put in place last year for the first time a filing fee for particular transactions, and and it noted specifically all the way down to the category of filings for investments below $50,000 or for below $500,000, and so indicating very clearly its intent to look at those investments. And so it's frustrating. I do think that as a de facto matter, you are still a lot more likely to attract CFIUS attention the larger your investment gets. And that's just because, in terms of how CFIUS actually notices investments that don't get filed, it's still bound by actually finding out about the investment somehow, through a press release, through a story in a trade publication, be it, TechCrunch, Crunchbase, or PitchBook here in the United States, or, other equivalent publications. Or, again, going back to the old school, the front page of the Wall Street Journal, or alternatively, what CFIUS has established here in the United States is a tip line where parties can contact CFIUS to tell them privately about deals that they think may not have been filed that they're interested in seeing CFIUS take a look at, which unsurprisingly has become a subject of discussion in terms of parties interested in making trouble for competitors in the business market. Yep. So, there are ways that CFIUS has to learn about things, and there are a number of them, but at the end of the day, their powers aren't infinite and they're not clairvoyant. And so, I do think that the larger transaction is, the more likely it is in some way to attract CFIUS attention. And I would not be surprised if your experience is similar as the NSI bill rolls out.
Yeah. Okay, perfect. Well, we're at the top of the hour. So, I mean, Nick, I'll hand back to you, but to wrap up.
Thanks, Ross, and thank you, Stacey, Josh, Sarah, and Ross. That's been really superbly helpful, very insightful. A moving target, I expect, and a lot more to follow. As I mentioned at the top, we'll put the content on the CIC website and circulate the slide deck to all the attendees. So thank you very much for joining.
Great, thank you.
Thank you. Bye.